Hello, my name is David Miklas. I'm a partner and shareholder with the law firm of Richardson & Koch with offices in West Palm Beach and Fort Pierce, Florida. I practice all types of labor and employment law, exclusively representing management, which are employers, including both private employers as well as Florida municipalities. Now this includes employment discrimination, retaliation, wage hour, which is the same as minimum wage, overtime law, NLRB practice, collective bargaining, arbitration, OSHA, ERISA, agricultural labor law, and public employment law, as well as nonprofit law. Now, I've co-authored a LexisNexis expert commentary in the field of employment law, and for the past 17 years, I've been a contributing author and editor for two leading labor and employment law hornbooks. I've graduated from the University of Florida College of Law. Now, today I'm here to talk to you about the Americans with Disabilities Act of 1990, which is known as the ADA. The ADA prohibits discrimination against employees or applicants on the basis of a disability. The ADA covers employers with 15 or more employees. The employee or applicant may present either direct evidence or circumstantial evidence that he or she was discriminated against because of his disability. Now, if the employee does not have direct evidence, then they may alternatively proceed under the traditional McDonnell-Douglas burden shifting framework. To qualify as direct evidence of discrimination, a document or a workplace comment must be four things. 1, age-related. 2, proximate in time to the termination. 3, made by an individual with authority over the termination. And 4, related to the employment decision. Now, direct evidence is what we call smoking gun, where, for example, if a supervisor says, "Fire Bill, he's too old," that is an example of direct evidence of discrimination. Now, to make out a prima facie case with circumstantial evidence, which is not direct evidence, the employee must show three things. 1, that the worker has a disability or was regarded as disabled. 2, that he was qualified for the job. And 3, that he was subject to an adverse employment decision, such as being fired or not promoted, on account of his disability. Now, if he or she, I'll just be using the term he throughout this, but if he makes that showing, then a presumption of discrimination will arise, and the employer must articulate a legitimate, non-discriminatory reason for the adverse employment action. At that point, if the employer can show that legitimate, non-discriminatory reason, then the burden shifts back to the employee or the applicant, the plaintiff, to produce evidence from which a jury could conclude that the employer's articulated reason is pretextual. Under the ADA, an individual suffers from a disability if that individual has a physical impairment that substantially limits one or more major life activities. Now, before the year 2008, courts frequently ruled that the employee did not meet the standard of showing that their impairment substantially limited one or more major life activities. So in 2008, Congress passed the ADA Amendments Act, or the ADAA, and that act specifically disapproved of prior United States Supreme Court decisions. So the 2008 amendments to the ADA require the courts to construe the substantially limits standard in favor of broad coverage. So after the 2008 amendments, the question that the courts will ask is whether the employee's impairment substantially limits his ability to perform a major life activity as compared to most people in the general population. So what is a major life activity? The statute itself tells us that major life activities include caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, a lot of things, learning, reading, concentrating, thinking, communicating, and working. Now, the ADA also protects not just someone who is disabled, but also those who are subjected to discrimination because they are regarded as having an actual or perceived physical or mental impairment, whether or not the impairment limits or is perceived to limit a major life activity. This means that an employer's unfounded concerns or mistaken beliefs or fears or myths or prejudice about disabilities are just as disabling as actual impairments under the law. So an employer's belief that employees injury resulted in substantial impairment, even if that view was mistaken, will mean that a court can find that an employee was in fact disabled under the statute. So that brings us to the second prong of the employee's prima facie case. Remember, the first prong of the employee's prima facie case using circumstantial evidence was that the employee or applicant has a disability or was regarded as disabled. The second prong is that he was qualified for the job. Now, the court will look at whether, despite the employee's impairments, whether he was still qualified for the position. So in order to be qualified, the employee or applicant must be able to show that he could either, one, perform the essential functions of the job in spite of his disability, or two, that a reasonable accommodation of his disability would have enabled him to perform the essential functions of his job. So if an employee asks for X, but even if the employer gave him what he asked for, then the employee would, if the employee asks for a specific accommodation, let's just call it X, and even if the employer gave him that accommodation, but the employee would still not be able to perform the essential functions of his position, then he would not be a qualified employee. So he would fail to show prong 2 of his prima facie case. Now, prong 3 is that the employee must show that he was subject to an adverse employment decision on account of his disability. This is the causal connection. Now, the question of whether an employer has asserted a legitimate, non-discriminatory reason for the action, the termination or rescinding an applicant's offer of employment, a burden that is usually easily satisfied by an employer. Now, such a reason may be that the employer decided to reduce the workforce at that site, or that the employer found a more experienced applicant, which is not connected with the employee's physical impairment. Now, summary judgment rulings, which are made by a judge before a trial even happens, those type of rulings in employment discrimination cases based on circumstantial evidence often boil down to a difficult assessment of pretext. Now, failure to accommodate is another area where battles often take place between employers and employees. And the ADA's prohibition on disability discrimination includes not making a reasonable accommodation to the known physical or mental limitations of an otherwise qualified individual with a disability, unless the employer can demonstrate that the accommodation would impose an undue hardship on the operation of the business of the employer. Now, under the ADA, a reasonable accommodation may include job restructuring or part-time or modified work schedules, or reassignment to a vacant position, or even the employer acquiring or modifying equipment or devices, sometimes appropriate adjustments or modifications of examinations, or training materials or policies, the provision of a qualified reader or interpreter. Those are all types of accommodations. In fact, some real-world examples would be things such as a deaf applicant may need a sign language interpreter during the job interview, or an employee with diabetes may need regularly scheduled breaks during the workday to eat properly and to monitor blood sugar and insulin levels. Another example would be a blind employee may need someone to read information posted on a bulletin board, or an employee with cancer may need leave to have radiation or chemotherapy treatments. Now, some employers can accommodate these types of things, and some cannot. The key is whether there is first a duty to accommodate, and if so, is the requested accommodation reasonable? So, the ADA provides a right to a reasonable accommodation, not the employee's preferred accommodation. This means that a disabled employee has no right to a promotion, to choose what job to which he will be reassigned, or to receive the same compensation that he received previously. Now, an undue hardship is defined as an action requiring significant difficulty or expense when considered in light of factors such as the employer's size or financial resources and the nature and structure of its operations. An employer is not required to lower the quality or production standards in order to make an accommodation. That would not be reasonable. Also, an employer is not obligated to provide personal use items such as glasses or hearing aids. Now, a plaintiff, which is the employee or the applicant, must initially be a qualified individual in order to sustain a failure to accommodate claim. Now, if an employee is both disabled and qualified for the position, that is when the employer looks at whether the employer should provide an accommodation. In general, an employee or applicant must request an accommodation, which requires the employer to engage in what the EEOC calls an interactive process that considers that possibility. However, an employee or applicant is excused from asking for an accommodation in a situation in which the employer is unquestionably aware of the disability, such as when the employer receives a doctor report recommending accommodations. So if an employee or applicant bears a responsibility of requesting an accommodation only when the disability resulting limitations and necessary reasonable accommodations are not open, obvious, and apparent to the employer, that's when the plaintiff bears that responsibility of requesting the accommodation. Now, requests for accommodations need not be in writing. They do not need to specifically mention the Americans with Disabilities Act or use any kind of buzz terms or exact phrases, reasonable accommodation. However, the employee's request must be sufficient to provide the employer with adequate notice of both the disability and the employee's desire for accommodations for that disability. Now, once on notice of an employee's disability and request for accommodation, the interactive process requires the employer to take some initiative to communicate with the employee and consider potential reasonable accommodations that could overcome the employee's limitations. An employer cannot escape its duty to engage in that interactive process simply because the proposed accommodations, those accommodations proposed by the employee, are not reasonable or would not prevail in litigation. Now, after an employer becomes aware of an employee's disability, the employer must engage in a good faith interactive process in order to determine if a reasonable accommodation can be accomplished. Now, this process requires three things. One, direct communication between the employer and the employee to explore in good faith the possible accommodations. Two, consideration of the employee's request. And three, offering an accommodation that is reasonable and effective. Now, remember, an employer is not obligated to provide the employee an accommodation that he requests or prefers. The employer only need to provide some reasonable accommodation. Now, the employee bears the initial burden to show the existence of a reasonable accommodation. Now, sometimes the case will turn on who caused the breakdown of that interactive process. An employer may give the employee a list of job functions for the employee to have their doctor review. And the courts have found that this is a reasonable attempt on behalf of an employer to understand the employee's need for accommodations. Now, there may be letters going back and forth between the employer and the employee, and it is not uncommon for an employer to make multiple requests that the employee provide more detailed explanations of how their disability would impact their ability to perform the essential functions of their position. Now, this type of employer requesting information will probably be used to show a good faith effort on part of the employer to seek reasonable accommodations. And if the employee fails to provide responsive information detailing his need for workplace accommodations, it could be fatal to the employee's discrimination claim. Now, this is a summary of how the ADA works in the real world. Thank you.